Thank you for visiting the Combs Waterkotte website and taking the time to listen to our free legal audiobook, Telling Your Side of the Story, Contesting an Order of Protection. Combs Waterkotte specializes in defending individuals served with orders of protection in Missouri. We've published this ebook to help you understand the process, build a solid defense, and protect your rights. With extensive experience handling orders of protection and over a dozen of successful appeals, we can guide you through every step, from understanding the initial ex parte order to contesting a full restraining order in court. This free ebook from Combs Waterkotte walks you through every step of the order of protection defense process. Learn why acting fast is crucial, what qualities to look for in a lawyer, key questions to ask during a consultation, and red flags to avoid. With this book, you can get the knowledge you need to make an informed decision and protect your rights. With the introduction out of the way, let's get started. Chapter 0. Contesting an Order of Protection. Introduction. Whether you've been served with an order of protection unexpectedly, or you've been involved in a situation that led to false accusations, facing a protection order can be an overwhelming experience. The thought of having your freedoms restricted, potentially losing access to your home or children, and dealing with the long-term impact on your personal and professional life can cause significant stress, especially if this is your first encounter with the legal system. It's a situation that can leave you feeling isolated and uncertain about how to contest the order and tell your side of the story. At Combs Waterkotte, we specialize in defending individuals served with orders of protection in Missouri. We've published this ebook to help you understand the process, build a solid defense, and protect your rights. With extensive experience handling these types of cases and over a dozen of successful appeals, we can guide you through every step, from understanding the initial ex parte order to contesting a full order in court. In this ebook, we'll cover essential strategies and common mistakes to avoid when facing an order of protection. Understanding orders of protection. The difference between ex parte and full orders and what to expect when served with an order. Legal framework and your rights. An overview of Missouri statutes and how they impact your case. Receiving an order of protection. Immediate steps to take after being served and how to avoid common mistakes. Building your case. Key strategies for gathering evidence and presenting your side effectively in court. Contesting the order. Understanding the court hearing process and defending yourself against false allegations. Common defenses, legal arguments, including challenging credibility and proving a lack of harm. After the hearing, what to expect if the order is upheld or dismissed, and your options for appeal. Modifying or dismissing an order. How to change or end the order if circumstances have changed. Moving forward, steps to protect yourself from future legal issues and restore your reputation. By applying the information and strategies in this ebook, you will protect your rights, understand the legal process, your rights, and how to fight false claims, strengthen your defense, learn how to gather evidence and present your case effectively in court, minimize legal consequences, discover ways to reduce the long-term impact of an order of protection on your personal and professional life. Facing an order of protection can be stressful, but with the right knowledge and legal strategy, you can take control of the situation and work towards the best possible outcome. This ebook is designed to empower you with practical advice to protect your future. While this book provides valuable guidance, it is not a substitute for personalized legal counsel. Always consult with an experienced attorney to tailor your defense to your specific case. With the right approach and the right order of protection attorney by your side, you can navigate the legal complexities with confidence and competence. Chapter 1. Understanding Orders of Protection in Missouri. If you've recently been served with an order of protection in Missouri, you might be feeling confused, frustrated, or overwhelmed. Or you might just be wondering, what the heck is going on? The legal terms and processes can be intimidating, especially if this is your first encounter with the court system. In this chapter, we will break down the basics of orders of protection in Missouri, focusing on what they mean, the types you might encounter, and the potential consequences of having one filed against you. Definition and types of orders of protection in Missouri. An order of protection is a legal document issued by a court to protect one person, the petitioner, from another person, the respondent. It typically aims to prevent contact between the two parties to protect the petitioner from threats, violence, harassment, or stalking. Orders of protection are often associated with domestic violence cases, but they can also be filed in situations involving stalking or harassment by someone outside the family. There are two main types of orders of protection in Missouri. First, Ex Parte Order of Protection. This is a temporary protection order granted without the respondent being present. It is often issued based solely on the petitioner's claims of abuse, stalking, or harassment. Because ex parte orders are emergency measures, they are usually granted quickly and can take effect immediately once issued. Missouri Revised Statute Section 455.035 stipulates that for an ex parte order to be granted, there must be good cause, which constitutes an immediate and present danger of domestic violence to the petitioner or the child. Whether or not there is good cause to grant the order will depend on the judge's evaluation of the facts of the case. An ex parte order can contain a variety of provisions that may affect your daily life, such as prohibiting you from contacting the petitioner, restricting your ability to visit certain locations, including your own home if you live with the petitioner, or limiting your access to your children. The key thing to understand here is that the ex parte order is short-term. It is designed to provide immediate relief to the petitioner until both sides can present their cases at a full hearing. In Missouri, this hearing typically takes place within 15 days of the ex parte order being issued. Second, full order of protection. A full order of protection can only be granted after a hearing in which both parties, the petitioner and the respondent, accused, have the opportunity to present their evidence and tell their side of the story. If the court finds the petitioner's evidence compelling enough, it will grant a full order of protection, which can last anywhere from 180 days to 10 years. This order may be renewable, meaning that the petitioner can request extensions as the expiration date approaches. The burden of proof for granting a full order of protection is a preponderance of the evidence, meaning the petitioner must prove they are simply more likely than not to be in danger. The consequences of a full order are much more far-reaching than those of an ex parte order. A full order can impact your ability to own firearms, affect custody arrangements for your children, limit where you can live or travel, and influence your personal and professional relationships. Who can file for an order of protection in Missouri? In Missouri, orders of protection are most commonly associated with cases of domestic violence. However, you don't necessarily need to be a current or former spouse or intimate partner of the petitioner to have an order filed against you. The law allows for a wide range of relationships and circumstances that could result in an order of protection. A petitioner may be eligible to file an order of protection against you if you are a current or former intimate partner of the petitioner, spouse, ex-spouse, or someone with whom the petitioner has a romantic relationship. A family member or household member. This includes relatives by blood or marriage, people who live together, or even roommates. A co-parent of a child with the petitioner. An acquaintance or stranger accused of stalking, harassment, or sexual assault. Even someone who has no familial relationship with the petitioner can be served if they are accused of those acts. Consequences of having an order of protection against you. While being served with an order of protection is a civil matter and not a criminal one, unless you violate it, the consequences can still be long-lasting, especially if the order is upheld after the hearing. Here are some of the potential consequences. Restrictions on contact and movement. The most immediate consequence of an order of protection is that it restricts your ability to contact the petitioner in any form. This includes physical proximity, phone calls, text messages, emails, and social media communication. Violating these terms could lead to criminal charges, even if the contact was unintentional or the petitioner initiated it. Though, in those circumstances, you can still have a right to defend against the claims with the help of a criminal defense attorney. You may also be prohibited from going to certain places, such as the petitioner's home, workplace, or other locations they frequent. Impact on custody and visitation. If you share children with the petitioner, an order of protection can have a significant impact on your parental rights. The court may place restrictions on your ability to see or contact your children, or even deny visitation altogether. In some cases, the court may award temporary custody to the petitioner as part of the order. It's important to know that these custody arrangements are temporary, but they could influence the outcome of future custody disputes. Firearm restrictions. Under federal law, individuals who are subject to a full order of protection are typically prohibited from possessing firearms. This can be especially significant if you are in law enforcement, the military, or another profession that requires the use of firearms. The restriction goes into effect immediately when a full order is granted, and violating it can result in serious criminal penalties, including imprisonment and hefty fines. Damage to reputation and employment. Orders of protection are part of the public record, which means that potential employers, landlords, or even future romantic partners may be able to find out about the order. This can damage your reputation and create barriers in both your personal and professional life. Certain jobs, especially those that involve security clearances or working with vulnerable populations, may become inaccessible if you are under a protection order. Criminal consequences of violating the order. Violating the terms of an order of protection is a criminal offense in Missouri. Even if the violation seems minor, such as accidentally running into the petitioner at a public event, it can lead to immediate arrest, fines, and possibly jail time. In Missouri, violating an order of protection is typically charged as a Class A misdemeanor, which could result in up to 1 year in jail and/or a $2,000 fine. If you have a prior conviction for violating an order of protection, subsequent violations can be charged as a Class E felony, which carries a longer sentence and more severe penalties. Understanding the basic facts about orders of protection is the first step in preparing to defend yourself. In the next chapter, we will dive into the legal framework and your rights under Missouri law, so you'll know exactly what to expect and how to navigate the process effectively. Stay calm, take the time to understand your situation, and remember that being served with an order of protection does not mean the case is closed. You still have the opportunity to tell your side of the story. Chapter 2. Legal Framework and Your Rights. Understanding the legal framework behind orders of protection in Missouri will help you contest them effectively. In this chapter, we'll cover the statutes that govern protection orders, the civil and criminal implications of violating an order, and the court process that follows being served. Missouri statutes and laws on protection orders. In Missouri, orders of protection are governed by 455 of the Missouri Revised Statutes: abuse, adults and children, shelters, and protective orders. This chapter lays out the criteria and process for obtaining a protection order, as well as the rights of both the petitioner, the person seeking protection, and the respondent, the person the order is filed against. One of the key aspects of the law is the burden of proof. To obtain a full order of protection, the petitioner must prove that it is more likely than not that the alleged abuse, harassment, or stalking occurred. This standard, known as preponderance of the evidence, is lower than the beyond a reasonable doubt standard used in criminal cases. Essentially, the judge must believe that the petitioner's claims are more likely to be true than false. How long do orders of protections last in Missouri? If the petitioner does not meet the burden of proof, the order will not be granted. If the judge determines that the evidence does meet the preponderance of evidence standard, they will issue a full order of protection, which can last from 180 days to 10 years, depending on the circumstances. Missouri Revised Statute Section 455.040 dictates how the court decides how long an order of protection can last. In Missouri, the length of an order of protection depends on the specific circumstances of the case and the court's assessment of the level of danger posed by the respondent. Full order of protection. After a hearing, the court can issue a full order of protection for at least 180 days, but no more than 1 year. However, if the court determines that the respondent presents a serious danger to the physical or mental health of the petitioner or a minor household member, the order can last for at least 2 years and up to 10 years. Renewal of the order. Upon the petitioner's request, a full order of protection may be renewed annually. In serious cases where the court finds that the respondent remains a significant threat, the renewal can extend the order for at least 2 years and up to the lifetime of the respondent. Automatic renewal. The court can include a provision for automatic renewal unless the respondent objects 30 days before the order expires. If no hearing can be held before the original expiration date, an ex parte order may be issued to maintain protection until a new hearing is held. Civil versus criminal implications of an order of protection. While the order of protection itself is a civil matter, the consequences of violating that order can quickly lead to criminal charges. Civil nature of the order. An order of protection is meant to address issues like harassment, stalking, or abuse in a civil manner, without involving criminal charges unless the terms of the order are violated. The purpose is to protect the petitioner from future harm or criminal acts by legally limiting the respondent's actions, e.g., prohibiting contact, staying away from certain locations. Criminal consequences of violating an order. Once an order is in place, any violation of its terms is considered a criminal offense under Missouri law. Missouri Revised Statutes, Section 455.085. A first-time violation is typically charged as a Class A misdemeanor, which could result in up to 1 year in jail and/or a $2,000 fine. However, if you have a prior violation, or if the violation involves serious misconduct, you could be charged with a Class E felony, which carries more severe penalties, including up to 4 years in prison. These criminal charges are separate from any criminal charges stemming from your alleged actions during the violation, for example, if you're accused of criminal stalking. Federal firearms ban. Another critical aspect of an order of protection is the potential for a federal firearms ban. Under 18 U.S.C. Section 922G, Individuals who are subject to a full order of protection are prohibited from purchasing or possessing firearms. This is particularly significant if you work in law enforcement, security, or any profession that requires the use of a firearm. Violating this federal law can result in up to 10 years in prison and significant fines. The Order of Protection Court Process in Missouri. If you've been served with an ex parte order, the court process follows a strict timeline. Missouri law requires that a full order hearing be held within 15 days of the issuance of the ex parte order, although it can be extended if necessary. Step 1. Ex parte order. The process begins with the petitioner requesting an ex parte order. This is an emergency, temporary order that can be granted without the respondent being present or informed beforehand. The ex parte order provides immediate protection to the petitioner and remains in place until the full order hearing. Step 2. Full order. Hearing. The full order hearing is your opportunity to contest the claims made by the petitioner. At the hearing, both sides and your attorneys will have the opportunity to present evidence, call witnesses, and cross-examine each other. The judge will review all the evidence before deciding whether to grant or dismiss the full order of protection. Presenting your case. You can present any evidence that disproves the petitioner's claims, such as text messages, emails, social media communications, and witness testimony. It is essential to stay composed, consult with an order of protection defense attorney, and present a clear and factual defense. Outcome of the hearing. After reviewing the evidence, the judge will either grant the full order or dismiss the ex parte order, meaning no further legal restrictions will be placed on you. If the order is granted, you will need to strictly comply with its terms to avoid criminal consequences. In the next chapter, we'll dive into the steps you should take immediately after being served with an ex parte order, and how to start preparing for your full order hearing. Chapter 3. What to do after being served with an ex parte order of protection in Missouri. Being served with an order of protection can be surprising, stressful, and even make you feel ashamed. But how you handle the situation right from the start will have a major impact on the outcome. This chapter will guide you through the immediate steps to take after being served, explain the importance of understanding the ex parte order, and help you prepare for the full order hearing, all while avoiding common mistakes that could hurt your case. Immediate actions after being served an order of protection in Missouri. The moment you are served with an order of protection, you need to remain calm and respond in a calculated and careful manner. The following steps are critical to ensure you are prepared for the legal process ahead. 1. Read the order carefully. As soon as you receive the order, read it thoroughly. The order will outline specific terms you must follow, such as no contact with the petitioner, staying away from certain locations, e.g., the petitioner's home or workplace, and potentially even custody restrictions if children are involved. Ensure that you fully understand these terms, as any violation, no matter how minor, can result in criminal charges, which could include jail time or fines. You may also want to review the specific laws that define violations of protection orders in Missouri, such as Missouri Section 455.085. 2. Comply immediately. Compliance isn't optional. Whether the claims are true or false, you must comply with the terms of the order until the full order hearing. Even a brief or accidental violation can result in criminal consequences. You will have your opportunity to have the order of protection dismissed later, but soon. Avoid any form of contact with the petitioner. This includes not just direct contact like phone calls or text messages, but also indirect forms such as social media interactions or driving by their home. Third, plan for the hearing. Once the ex parte order is issued, a hearing for a full order of protection will typically be scheduled within 15 days. This gives you a limited window to prepare your defense. Begin organizing your defense strategy immediately by gathering any relevant documents, communications, and witness testimony that can disprove the petitioner's claims. Fourth, hire an order of protection defense attorney. You should never walk into a courtroom without a defense lawyer, and that's especially true with an order of protection, as the court's ultimate decision has long-lasting consequences. A skilled attorney will help you navigate the process, ensure that your rights are protected, and assist in building a strong case for the full order hearing. An experienced attorney will take control of the courtroom and argue your case on your behalf. Understanding a Missouri ex parte order. An ex parte order is a temporary protection order issued without your knowledge or presence in court. It is intended as an immediate, short-term measure to protect the petitioner from perceived harm. But it is not permanent and can only remain in effect until the full order hearing. What it does: the ex parte order can include restrictions such as no contact, maintaining a certain distance from the petitioner, and sometimes limitations on seeing your children if applicable. Remember, while these terms are temporary, any violation of the ex parte order can still lead to criminal charges. Why you must attend the full order hearing. The ex parte order is based solely on the petitioner's claims, without you being able to present your side of the story. The full order hearing, which typically happens within 15 days, is your chance to contest the order, present evidence, and cross-examine the petitioner. Failing to attend this hearing will likely result in a full order of protection being granted by default, which could have much more serious and long-term consequences for you. Preparing for the full order hearing. Your ability to successfully contest the protection order largely depends on how well you prepare for the full order hearing, along with the skill and experience of your attorney. Here's how, with your defense lawyer's help, you can get ready. 1. Gather evidence. Begin collecting any evidence that can support your defense and discredit the petitioner's claims. This could include text messages, emails, or social media exchanges that show the petitioner's accusations are unfounded or exaggerated. Witnesses who can testify on your behalf. These could be individuals who were present during incidents or who have direct knowledge of the petitioner's behavior. Alibis or other documents that demonstrate you were not present at the alleged events or incidents. 2. Document your own story. Write down your version of events, including specific dates, times, and locations where the alleged incidents occurred. Be as detailed as possible. This will help you stay consistent when presenting your side of the story to the court. 3. Stay organized. Keep all documents, communications, and evidence well organized and easily accessible for the hearing. Your attorney will also need to review these materials in order to build your defense strategy, and keeping documents organized will help them present the best possible defense. 4. Prepare to stay composed in court. Court hearings can be emotionally charged, especially when accusations of abuse or harassment against loved ones are involved. However, you are more likely to achieve the best possible resolution to your case if you remain calm, respectful, and composed throughout the process. This will reflect positively on your credibility in the eyes of the judge. Acting with emotion may make it appear that the alleged events are more likely to be true. Common mistakes to avoid after receiving an order of protection. Unfortunately, many people unknowingly make mistakes after being served with an order of protection, often before they consult with an attorney. Avoiding these pitfalls can make a significant difference in the outcome of your case. Failing to appear in court. One of the most damaging mistakes you can make is not showing up to the full order hearing. If you do not attend, the judge will likely grant the petitioner's request for a full order of protection by default, without hearing your side of the story. This could result in severe restrictions being placed on you for up to 10 years. Appealing an order of protection is much more challenging once a full order is granted. Violating the Ex Parte Order. Even if you believe the petitioner's accusations are false or exaggerated, do not violate the terms of the Ex Parte Order. Something as simple as sending a text message to the petitioner or accidentally being in the same place as them could lead to criminal charges and weaken your defense at the full order hearing. Not gathering evidence. It's not enough to show up and deny the petitioner's claims. You need evidence to support your case. Failing to prepare and gather supporting documents, communications, or witnesses will make it much more difficult to convince the judge to dismiss the order. Because the burden of proof, preponderance of the evidence, only requires the judge to believe the petitioner over you, your defense cannot simply be that there isn't enough proof, as it might be in a criminal case. Not hiring an attorney. Deciding to represent yourself in a protection order case can severely impact your chances of success. An attorney knows the nuances of the legal process, understands the burden of proof, and can cross-examine the petitioner effectively. They will help you understand your rights, organize evidence, and present a compelling defense, increasing your likelihood of a favorable outcome. By avoiding these common mistakes, you can improve your chances of contesting the order effectively. In the next chapter, we will dive deeper into building your case and the strategies you can use to present your defense in court. Chapter 4. Building your case. When contesting an order of protection, your ability to effectively present your side of the story depends largely on the evidence you gather, the skill and experience of your defense attorney, and how your side is delivered in court. This chapter will guide you through collecting relevant evidence, presenting your defense clearly and confidently, and ensuring you have the best possible legal representation. Gathering evidence for an order of protection hearing. The foundation of any solid defense is evidence. Whether you're defending against allegations of harassment, domestic violence, or stalking, collecting proof that supports your version of events can discredit the petitioner's claims. Here's a breakdown of the types of evidence you should focus on. 1. Communications. Collect text messages, emails, voicemails, and social media posts that may show the interactions between you and the petitioner. Look for messages that indicate consent, cooperation, or any signs of false allegations. If the petitioner has contacted you after filing the ex parte order, this could weaken their case. Ensure that all communications are preserved in their original format. Screenshots and saved conversations can be very useful in court. 2. Photos, videos, and audio recordings. If the incidents mentioned in the petitioner's claims happened in public or where surveillance footage is available, try to obtain photos or video evidence that contradicts their version of events. For example, video footage showing that you weren't present at the alleged time or location can be particularly helpful. If you have a dog camera, doorbell camera, or other type of camera in your home, you can also use footage from those to dispute the petitioner's version of events. Legally obtained audio recordings that show conversations where the petitioner is calm, contradicting claims of being scared or threatened, or where they may have been the aggressor. Under Missouri Revised Statute Section 542.402, Missouri is a one-party consent state, which means if you are recording a conversation that you are a part of, you don't need the other person's permission to record it and can do so without them knowing. 3. Witness statements. Witnesses who were present during any of the incidents described in the petition can be critical to your defense. Obtain written statements or affidavits from anyone who can provide first-hand accounts of the situation. Your order of protection defense attorney will also likely want them to testify in court. If the petitioner has made claims that involve interactions with others, such as co-workers or neighbors, you can ask those individuals to testify about their knowledge of the situation. You can also call character witnesses, people who know you and your relationship well and can tell a different story about your relationship. Fourth, alibis and records. If you weren't at the scene of the alleged incident, secure any alibi information that proves your whereabouts. This could include work logs, receipts, or witnesses who can confirm you were elsewhere. Keep copies of any previous communications with law enforcement or legal authorities that might contradict the petitioner's claims or prove a pattern of behavior on their part. 5. Character references. Character references from respected individuals in your community, such as colleagues, employers, or neighbors, can help demonstrate that the allegations made against you are inconsistent with your character or typical behavior. While these references might not speak to the specific incident, they help shape how the court perceives you. You can also call people who know your relationship with the petitioner well and can provide context or a different version of the relationship dynamic. 6th, police reports. Police records or reports that show no incidents occurred on dates or times mentioned by the petitioner. Reports of past false accusations or other legal records showing patterns of making unsubstantiated claims. 7. Medical records. If the petitioner claims you caused physical harm, your own medical records or third-party medical reports can help show that the injuries they claim to have suffered do not align with what you could have done or simply do not exist. How to tell your side effectively. Once your evidence is gathered, it's important to present your case clearly and effectively. Your Order of Protection defense attorney will instruct you on how to approach telling your side of the story in a way that resonates with the court. Stay calm and composed. Emotional outbursts can damage your credibility, so it's important to stay calm during the hearing. The judge will be looking for rational, well-supported explanations. Even if the petitioner makes claims that anger or frustrate you, staying composed will help the court see you as credible. Stick to the facts. Focus on the facts of the case. Avoid making accusations or counterclaims that can't be backed up by evidence. If the petitioner's statements are inconsistent, your attorney can use your evidence to highlight those contradictions, but avoid attacking them personally. Judges appreciate arguments grounded in evidence rather than emotions. Highlight inconsistencies. If the petitioner has made conflicting statements or has previously engaged in behavior that contradicts their claims, be sure to point that out. For example, if they've reached out to you after filing the order, show evidence of that contact, as it may undermine their argument that they feel threatened. Keep your story organized. Before the hearing, create a timeline of events that's easy for the judge to follow. Organizing your defense in a logical way helps ensure the court understands your perspective. Be clear and concise, and avoid over-explaining. Hiring an Order of Protection defense attorney. Self-representation might seem like an option if you're confident in your ability to tell your side of the story. But contesting an order of protection is a serious legal matter that can have long-term consequences. Generally speaking, you should never go to court without at least consulting with a lawyer first. Here's why hiring an attorney is highly recommended. Legal expertise. An attorney who specializes in protection orders and family law knows the legal landscape and the procedural requirements of these hearings. They will understand the nuances of how Missouri law interprets harassment, stalking, or abuse, and how to effectively challenge those allegations. Cross-examination. One of the most critical aspects of contesting an order of protection is the ability to cross-examine the petitioner. An experienced attorney knows how to ask the right questions to highlight inconsistencies, falsehoods, or ulterior motives in the petitioner's testimony. Strategic presentation. Attorneys are skilled at presenting evidence in a way that the court finds compelling. They know what types of evidence hold the most weight and can anticipate what the petitioner's lawyer may argue. With an attorney's guidance, you can ensure that the court sees the strongest version of your case. Navigating the complexities of the law. Legal procedures can be confusing. From filing paperwork correctly to understanding the specific rules of the courtroom, having a lawyer ensures that you don't accidentally miss deadlines or violate court rules, which could harm your case. Representation beyond the hearing. If the court grants the full order of protection, your attorney can assist with appealing the decision or helping to modify or dismiss the order at a later date. Legal representation can provide long-term support in protecting your rights. While hiring an attorney might seem costly, the potential long-term impact of having an order of protection against you on your personal life, your job, and even your future relationships makes professional legal guidance well worth it. Look for an attorney who is experienced in order of protection cases and has won several of them before. In the next chapter, we'll explore how to contest the order effectively in the courtroom and what strategies can work in your favor during the hearing. Chapter 5. Contesting the order of protection in court. Once you've gathered your evidence and prepared your defense, the next step is contesting the order at the full order of protection hearing. This is where both you and the petitioner will have the chance to present your case, cross-examine each other, and provide evidence to the judge. In this chapter, we'll cover the process of the hearing, defense strategies you can use, how to effectively cross-examine the petitioner, and the importance of staying composed throughout the proceedings. You must attend the hearing. If you do not, the judge will grant the full order of protection. Likewise, if the petitioner does not appear, and you do, the case will be dismissed. Missouri Order of Protection Hearing Process. Overview. The full order hearing is your opportunity to contest the allegations made against you. It is formal and follows a specific structure. The hearing is structured to ensure both parties have the chance to offer evidence and testimony, and the judge's decision will be based on the preponderance of evidence. Here's a deeper dive into what to expect. First, opening statements. At the start of the full order hearing, both you and the petitioner, or your attorneys, will be given an opportunity to make brief opening statements. This is where you can set the tone for your defense. Your opening statement is the first chance to speak directly to the judge and outline the foundation of your case. Remember, while this is your opportunity to introduce your side of the story, you should avoid going into too much detail at this stage. Instead, your and your order of protection defense attorney should focus on providing the judge with a clear and concise overview of your defense. Think of this statement as a roadmap that highlights the key points you will be proving throughout the hearing. For example, if your defense revolves around the petitioner making false allegations or exaggerating certain events, state this clearly. Keep your statement grounded in fact and avoid emotional appeals or personal attacks, as the judge will be looking for a calm, rational presentation of your position. 2. Presenting evidence. During the hearing, both the petitioner and the respondent will present their evidence to support their claims or defense. According to Missouri law, this evidence can include written communications, witness testimony, photographs, and other relevant materials. The judge will review all submitted evidence to determine whether the allegations meet the legal standard for issuing a full order of protection. Evidence must be relevant and properly organized to ensure clarity during the hearing. How you conduct yourself, present evidence, and handle cross-examination can significantly impact the outcome of the hearing. This chapter focuses on courtroom strategy, guiding you on how to make your defense as effective as possible when contesting an order of protection. Additionally, any communications that occurred after the ex parte order was issued, such as the petitioner contacting the respondent, can be used to undermine the petitioner's claims. This is particularly important if the petitioner alleges fear or harassment, but continues to initiate contact. 3. Calling witnesses. Witnesses play a key role in supporting your defense. You can call individuals who have first-hand knowledge of the events in question. For example, a neighbor, co-worker, or family member who witnessed interactions between you and the petitioner can provide valuable testimony. It's also helpful to have character witnesses who can speak to your behavior and credibility. Missouri courts place significant weight on direct witness testimony, so ensuring your witnesses are credible and prepared to testify is critical. Witnesses should be able to refute specific claims made by the petitioner or offer alternative explanations for incidents. 4th, cross-examination. Both parties will have the right to cross-examine each other. This is your order of protection defense attorney's chance to question the petitioner about inconsistencies or falsehoods in their testimony. Likewise, they may also question you, so it's important to stay calm and respond carefully. 5th, judge's decision. The judge's decision will be based on whether the petitioner has met the preponderance of evidence standard, which means the judge must believe the petitioner's claims are more likely true than not. This lower burden of proof makes it essential to counter the petitioner's evidence effectively, as even minor inconsistencies in their testimony can work in your favor. The consequences of the judge's decision can last from 180 days to 10 years, and the full order may be renewable. If granted, the order can severely impact your daily life, including restrictions on your ability to own firearms, access certain places, or contact the petitioner. Therefore, contesting the order at this stage is much easier than appealing a full order that was already granted. Under Missouri Revised Statute Section 455.040, the judge will determine if you pose a threat to the petitioner or minor household member by evaluating the weight of the evidence, any history of your inflicting or causing physical harm, any history of your stalking or causing fear of physical harm, your criminal record, if any, whether you have had a full order of protection granted against you in the past, whether you have ever been convicted of a dangerous felony under Missouri law, if you have ever violated an ex parte or full order of protection, or if you have ever violated probation or parole. Cross-examination in an order of protection hearing. Cross-examination is one of the most important aspects of the hearing. It's your chance to challenge the petitioner's claims and demonstrate that their accusations are unfounded. Likewise, you'll also need to be prepared for when you are cross-examined. Responding to the petitioner's lawyer. When it's the petitioner's lawyer's turn to cross-examine you, they may ask leading questions designed to confuse you or elicit responses that support the petitioner's claims. Stay calm and take your time before answering. If you don't understand a question, ask for clarification. Be careful not to let your emotions take over, as an emotional response can damage your credibility. Keep your responses short and factual. Avoid going off on tangents or providing more information than is necessary. Effective cross-examination of the petitioner. When it's your turn to cross-examine the petitioner, your lawyer should focus on inconsistencies in their testimony. For example, If their timeline of events doesn't match up, or if they've changed their story, ask them questions that highlight these contradictions. Avoid hostile or sarcastic questioning, as this could work against you. Instead, use a calm and methodical approach to expose the weaknesses in their claims. If you believe the petitioner has an ulterior motive for filing the order, such as during a custody battle, your attorney may ask questions that might reveal their motivations without directly accusing them of lying. Staying composed during the hearing. The way you present yourself in court can influence how the judge perceives your credibility. Even if you have strong evidence, a lack of composure can undermine your defense. Handling emotions in court. It's natural to feel emotional when faced with serious accusations, but maintaining composure is critical. Emotional outbursts or visibly losing control can hurt your credibility, making the judge more likely to believe the petitioner's claims. Take deep breaths, stay focused on your defense, and don't let accusations provoke you into reacting emotionally. If the petitioner makes false or inflammatory statements, wait for your opportunity to respond during your testimony or cross-examination rather than interrupting. Body language and credibility. Nonverbal communication is just as important as what you say. Stay calm, make eye contact with the judge when appropriate, and avoid aggressive gestures like pointing or raising your voice. A composed demeanor can signal to the judge that you're credible, rational, and trustworthy. Chapter 6. Common Defenses in Missouri Order of Protection Cases. When contesting an order of protection, several defense strategies can be used to challenge the petitioner's claims and prevent a full order of protection from being granted. Each defense depends on the specific circumstances of the case, the evidence available, and the nature of the petitioner's accusations. Your order of protection defense attorney will help develop the best defense strategy for your case. Below are common defenses that may apply in your order of protection hearing. 1. False allegations. One of the most common defenses against an order of protection is to demonstrate that the petitioner's claims are exaggerated or completely fabricated. This can be done by presenting evidence such as communication logs, witness testimony, or other documentation that contradicts the petitioner's account. For example, if the petitioner claims harassment through text messages, you can provide full conversations that show the petitioner initiated contact or that the conversation was benign. If you can prove that the petitioner has a history of making false accusations, this can further support your defense. Collect evidence from prior incidents or disputes that may show a pattern of behavior. 2. Mutual conflict or self-defense. In many cases, both parties may have been involved in a heated argument or altercation, and the petitioner may be portraying themselves as the victim. By providing evidence of mutual aggression, you can argue that the petitioner is equally responsible for the conflict. This can mitigate the severity of the petitioner's claims and suggest that a full order is unnecessary. Missouri courts are generally not in favor of granting mutual orders of protection. If physical violence was involved, one of the most effective defenses is to demonstrate that you acted in self-defense. This requires proving that your actions were a response to an imminent threat and were necessary to protect yourself from harm. Witness statements, medical reports, or even surveillance footage can be used to support this defense. 3. Challenging petitioner credibility. In some cases, the petitioner may provide inconsistent details about the alleged incidents. Identifying and highlighting these discrepancies during cross-examination can cast doubt on their credibility. For example, if their account of the date or nature of an event changes between their written statement and court testimony, you can use this to challenge the accuracy of their claims. If there are ongoing legal battles such as a divorce or custody dispute, it may be possible to argue that the petitioner has an ulterior motive for filing the order of protection. By revealing that the petitioner stands to gain something, such as increased custody or a financial advantage, you can weaken their case. Fourth, lack of harm or threat. Orders of protection are typically granted based on the petitioner's claim that they are in fear of harm. If you can show that the petitioner's fear is unreasonable or disproportionate to the events described, you may be able to contest the order. For example, if the alleged harassment involved a minor disagreement where only some harsh words were exchanged, it may be insufficient to justify an order of protection. The petitioner must provide credible evidence that a threat exists. If there is a lack of physical harm, or the alleged actions don't meet the legal definition of harassment, abuse, or stalking, you can argue that the order is unnecessary. 5. Witness statements and character references. Witnesses who were present during the alleged incidents can provide first-hand testimony that refutes the petitioner's claims. If they can testify that no threat or abuse occurred, this can significantly bolster your defense. For example, a co-worker or neighbor who observed the interaction between you and the petitioner could clarify what actually happened. Having character references from neutral third parties can also be useful. These individuals can testify to your behavior and history, the nature of your relationship with the petitioner, and circumstances surrounding the alleged events. These witnesses offer support that you are not a threat or abusive. While they may not have witnessed the specific incident, their testimony can shape the judge's perception of your character. 6. Lack of evidence. Your order of protection defense lawyer may point out that the petitioner has failed to provide sufficient evidence to support their claims. The petitioner must make the judge believe their version of events is true, and if their accusations are based on vague, unsubstantiated claims, the court may dismiss the case. This is especially effective when the petitioner has no credible witness testimony, physical evidence, or supporting documentation to back their allegations. Unlike in a criminal case where the burden of proof is beyond a reasonable doubt, the burden of proof in an order of protection case is the preponderance of the evidence, meaning the judge will decide the case based on whose version of events they believe are more likely to be true. Even so, the petitioner generally still has to have enough evidence to convince the judge what they're saying is probably true. 7. No ongoing risk. Another common defense is to argue that even if an incident occurred, there is no ongoing risk of harm or harassment. The court may be more inclined to grant a full order of protection if it perceives an ongoing threat to the petitioner. However, if the event in question was isolated and there have been no further issues since, you can make the case that a protection order is unnecessary. For instance, if the alleged incident happened during a one-time disagreement or altercation, and there has been no attempt by you to contact or threaten the petitioner since, this can significantly weaken the petitioner's argument that they are still in danger. Additionally, showing that any misunderstandings or conflicts have been resolved amicably, if applicable, can further support the argument that the order of protection is not required to prevent future harm. The defense strategies you and your attorney choose to present will depend on specific circumstances of your case. In the next chapter, we will explore what happens after the hearing, including the possible outcomes and next steps. Chapter 7. What happens after an order of protection hearing? The outcome of your hearing can have significant and long-lasting effects on your life. Understanding the potential results and how to handle them will help you move forward. In this chapter, we will discuss the possible outcomes of the hearing, the appeal process if you disagree with the court's decision, and the long-term impact of an upheld order of protection. Possible outcomes of an order of protection hearing in Missouri. After both parties have presented their evidence and witnesses, the judge will make a decision. There are two primary potential outcomes. Dismissal of the order. If the judge determines that the petitioner's claims do not meet the legal standard for a full order of protection, the case will be dismissed. This means that the ex parte order will no longer be in effect, and any restrictions placed on you during the hearing process will be lifted immediately. While this is the ideal outcome for you as the respondent, it's important to note that the petitioner can still file future protection orders if new incidents occur. The dismissal only applies to the current case. Upholding the order. If the judge decides that the petitioner's evidence meets the preponderance of the evidence standard, and the petitioner's version of events is more likely to be true, the full order of protection will be granted. The order can be in effect for a period ranging from 180 days to 10 years, depending on the severity of the claims and the perceived risk to the petitioner. The full order will likely include restrictions such as no contact with the petitioner, maintaining a certain distance from their residence or workplace, and possibly limitations on child custody or visitation. The specifics of the order will be outlined by the court, and it's essential that you fully comply with its terms to avoid criminal penalties. Typically, the full order of protection will be granted for a period of 180 days up to 1 year. If the court finds that you pose a serious danger to the physical or mental health of the petitioner, they can extend the order to a period of 2 years to 10 years. Appealing an order of protection in Missouri. Under Missouri Revised Statute Section 455.060, if the judge upholds the order, you have the right to file an appeal with the Missouri Court of Appeals. The appeal process can be complex and has specific time limits to file, and you'll need an order of protection defense attorney to ensure you follow the correct procedures and to represent you in court. Filing a timely appeal. Appeals must be filed within a strict time frame after the court's decision, usually within 30 days. Missing this deadline can result in the loss of your right to appeal, so it's crucial to act quickly if you want to contest the ruling. Grounds for appeal. Successful appeals typically hinge on proving that the judge made a legal error. Simply disagreeing with the outcome is not enough. Suppose you presented substantial text message exchanges proving that the petitioner initiated contact after filing for the ex parte order, contradicting their claim of fear. If the judge disregarded this evidence and still granted the full order, you could appeal on the basis that the court failed to properly consider relevant facts that could have altered the decision. The appeal process. Once filed, the appeal will be reviewed by a higher court, and you may need to provide additional documentation or attend further hearings. The appeal court will either uphold the original decision or remand the case for a new hearing. This process can take several months, so patience is required. Consequences of a full order of protection in Missouri. If the court grants a full order of protection, it can include a range of restrictions and responsibilities, depending on the specifics of your case. You cannot commit or threaten to commit domestic violence, stalking, molesting, or disturb the petitioner's peace, including harming their pets. Simply put, you must avoid any actions or threats that could cause the petitioner fear or harm, including their pets. You might not be allowed to enter the petitioner's home, even if it's a place you own or rent together. Whether you share the home with the petitioner or they live there alone, the court can stop you from going inside or even coming near it. You cannot contact the petitioner in any way. This means no phone calls, texts, emails, or any other form of communication, including through third parties or social media. If you have children together, the court can decide who gets custody, with a preference toward the non-abusive parent. The court will decide where your children live, and they will likely stay with the parent who isn't accused of violence or harm. The court may set up a visitation schedule for you, but it can also deny visitation if it's not safe for the child. You might get specific times to see your children, but if the court believes your visits could harm them or endanger the other parent, they can deny visitation. The court can require you to pay child support if there isn't already an order in place. If there's no current child support order, the court may order you to provide financial support to the petitioner for the care of your children. If you're married, the court can order you to pay temporary financial support for up to 180 days. If you and the petitioner are legally married, you could be required to pay spousal support for a few months, depending on the situation. You may be ordered to keep paying rent or mortgage payments on the home the petitioner lives in, even if you're not there. If you've been financially supporting the petitioner, you could be required to continue making rent or mortgage payments on the residence they stay in. If the petitioner moves out and requests new housing, you may need to cover their rent. If the court decides you still need to financially support the petitioner, you could be asked to pay rent for a new place they move to. The court may let the petitioner keep certain personal items like cars, checkbooks, or keys. You could lose access to certain personal property, such as your car or important household items, if the petitioner is granted temporary possession. You may be prevented from selling or giving away property you share with the petitioner. The court might stop you from transferring, selling, or otherwise getting rid of any property that you own jointly with the petitioner. The court can order you to attend counseling or substance abuse programs. You may be required to take part in court-approved counseling or treatment programs to address violent behavior or substance abuse issues. You might have to pay for the petitioner's shelter or other services provided by a domestic violence center. If the petitioner has received housing or services from a domestic violence center, you may be responsible for covering those costs. You could be required to pay the petitioner's court costs. The court may order you to cover all legal fees and court costs that the petitioner incurred during the case. You might be required to pay for medical treatment the petitioner needed due to domestic violence. If the petitioner needed medical care because of the alleged abuse, the court might order you to pay those bills. The court can transfer phone billing responsibility for the petitioner or your children to the petitioner. If the petitioner is not the account holder for the phone plan, the court can transfer billing responsibility for their phone or your children's phones to them. The court can give the petitioner custody of your pet and order you to cover any vet bills caused by abuse. If there's a pet involved, the court may grant the petitioner custody of the animal and make you pay for any medical care it needed because of harm. You could be required to pay the petitioner's attorney fees. The court might also make you pay for the legal services the petitioner needed during the case. Long-term impacts of an order of protection. If the full order of protection is upheld, it can have lasting consequences beyond the immediate restrictions imposed by the court. Custody and visitation. If the order includes provisions regarding child custody, your ability to see or communicate with your children may be limited. Courts may award temporary custody to the petitioner, restrict visitation to supervised environments, or, in extreme cases, deny visitation altogether. These restrictions can last for the duration of the order and may influence future custody decisions in divorce or family court proceedings. Employment opportunities. Many employers conduct background checks, and a full order of protection can appear in public records. This may affect your ability to secure certain jobs, particularly those that require security clearances, involve working with vulnerable populations, such as children or the elderly, or jobs where trust and safety are critical. Additionally, if your current employer becomes aware of the order, it could impact your standing within your company, depending on the nature of your work. Public record. A full order of protection becomes part of your permanent public record, meaning anyone conducting a background check can see it. This can affect not only employment opportunities, but also housing applications, loan approvals, and other aspects of your personal and professional life. Unlike certain criminal convictions in Missouri, orders of protection cannot be expunged from public record. Impact on relationships. If the protection order remains in place for an extended period, it may strain relationships with family, friends, or new romantic partners. The presence of a protection order can raise concerns or create mistrust, even if the allegations were exaggerated or false. Understanding the consequences of the court's decision and the potential long-term impacts is the first step toward moving forward after the hearing. If the order is upheld, it's important to comply fully with all court-mandated restrictions and, if appropriate, explore legal options to appeal or modify the order over time. In the next chapter, we'll cover modifying or dismissing an order and how to protect yourself from future legal issues related to protection orders. Chapter 8. Modifying or dismissing an order of protection. Once a full order of protection has been granted, it doesn't necessarily have to remain in place for the entire duration. If circumstances change, you may be able to petition the court to modify or dismiss the order. This section outlines the steps required for making such a request, as well as the evidence needed to support your case. Missouri Revised Statute Section 455.060 details how and when an order can be modified or terminated. In layman's terms, modifying an order. Either you, the petitioner, or a court-appointed representative, like a guardian for a child, can ask the court to change the order of protection if there's a major change in circumstances. You need to file a request with evidence showing why the change is necessary. Full orders of protection are final and can be appealed, and they are only in effect for a set period of time. Child support, custody, and visitation. Any decisions made about child support, custody, or visitation in an order of protection will end if the court issues a new order related to those matters, usually under different Missouri laws. Future proceedings. The current order of protection won't stop future legal actions, like custody cases or other court proceedings. Divorce or legal separation. If you and the petitioner get divorced or legally separated, most parts of the protection order will end. However, requirements like attending counseling or staying away from the petitioner's home may still remain in place, unless the court says otherwise. Terminating an order. The protection order can end early if the petitioner asks the court to terminate it, and the court agrees. Before doing this, the court may ask questions to make sure the petitioner is asking to end the order voluntarily. Child custody. During divorce. If there's already a case for divorce or custody in another court, the order of protection can't change who gets custody of the children. The other court will handle that. Additionally, under Missouri Revised Statute, Section 455.060, modifying support or maintenance. If you want to change the amount of support or maintenance payments, like child or spousal support, you can only change future payments after you file for the modification. To get this change approved, you'll need to show that there's been a big and ongoing change in circumstances that makes the current terms unfair or unreasonable. Modifying custody. Custody arrangements can only be changed if something significant has happened since the original order, or if there was something important the court didn't know when the first order was made. The court has to believe that this change is necessary to serve the best interests of the child. Modifying visitation. The court can change visitation rights if the new arrangement would better serve the child's well-being and best interests. Steps for modifying or terminating a full order of protection. If you believe the terms of the order are no longer necessary or too restrictive, you can request that the court either modify or dismiss the protection order. Some common reasons for making such a request include: if you and the petitioner have resolved your issues, reconciled, or no longer require the order, this could be grounds for modification or dismissal. If a significant amount of time has passed without any further incidents, you may argue that the order is no longer necessary. To begin the process, you must file a motion with the court requesting the modification or dismissal of the order. This typically involves filling out court forms and attending a hearing where you and your attorney will need to explain why the order should be changed or lifted. The court will evaluate the situation and make a decision based on the evidence you present and any objections from the petitioner. See below for the appropriate court forms. Motion to terminate full order of protection. Request to dismiss petition for order of protection. Affidavit of changes in circumstance and motion to modify judgment of the full order of protection. Necessary evidence and legal process for modifying or terminating a full order of protection. To successfully modify or dismiss the order, you and your attorney will need to present compelling evidence that justifies your request. Some examples of necessary evidence include: evidence of reconciliation. If you and the petitioner have resolved your conflict, providing evidence such as communication records or testimony from both parties showing that the petitioner no longer feels threatened can support your case. Changed circumstances. You can provide evidence that circumstances have significantly changed, such as moving to a different area, no longer having contact with the petitioner, or showing that there have been no further incidents of alleged harassment or violence. Testimony from the petitioner. If the petitioner agrees that the order is no longer needed, their testimony or a written statement expressing their agreement can strengthen your request. It's important to follow the legal process carefully. You'll want to hire an order of protection defense attorney to ensure that all paperwork is filed correctly and that you're fully prepared for the court hearing. The judge will need to be convinced that the order is no longer necessary to protect the petitioner, and failure to present strong evidence could result in the order remaining in place. In the next chapter, we'll discuss how to move forward and protect yourself from any future legal issues, as well as how to restore your reputation if the order is dismissed. Chapter 9. Moving forward after an order of protection. Once an order of protection has been dismissed, expired, or resolved, it's important to take steps to move forward and rebuild your life. This chapter will focus on protecting yourself from future legal issues, restoring your reputation, and accessing resources to help you recover. Protecting yourself from future orders of protection. Even after an order is dismissed or expires, it's essential to avoid any behavior that could lead to future legal issues. Here are some ways to protect yourself. Avoid behavior that could be misinterpreted. Be mindful of your actions and interactions with the petitioner, even after the order is no longer in effect. Avoid any behavior that could be seen as harassment, stalking, or violating boundaries, such as showing up unexpectedly or trying to initiate contact. You need to respect the boundaries that were set during the process to prevent any further misunderstandings. Strict compliance with the order. While the order is in effect, comply fully with its terms, even if you disagree with them. Violating the order can result in criminal charges and make it more difficult to defend yourself in the future if another order is filed. If the court sees that you respected the legal boundaries, it will reflect better on you in case of any future disputes. Restoring your reputation. After an order of protection. Having an order of protection filed against you, even if it is dismissed, can affect your personal and professional life. Taking proactive steps to restore your reputation is important. Correcting public records. Once the order has been dismissed or expired, you may want to check public records to ensure they are updated. If your case was dismissed, make sure that any relevant documentation reflects this outcome, especially if it impacts job applications, housing, or other areas of your life. Addressing issues with employers. If your employer became aware of the order and it affected your professional standing, consider having a conversation to explain the resolution. Providing documentation of the dismissal or the expiration of the order may help clear up any concerns your employer might have had. Available resources and support. Navigating the emotional and legal challenges of having an order of protection filed against you can be overwhelming. There are resources that can help you cope and rebuild. Legal aid. While possibly not to the same level of advocacy as an experienced order of protection defense attorney, free or low-cost legal services are available to help you understand your rights and navigate any future legal issues. They can also assist with modifying or dismissing orders and advising you on how to protect yourself moving forward. Counseling services. Dealing with the stress of a protection order can take an emotional toll. Counseling services, whether through a therapist or support group, can help you process your emotions, rebuild your confidence, and manage any residual stress from the experience. Support groups. Connecting with others who have faced similar challenges can provide emotional support and practical advice on how to move forward. Support groups can offer a safe space to share your experiences and learn from others. By taking these steps, you can move forward with confidence and work toward restoring stability in your personal and professional life. In the next chapter, we'll explore frequently asked questions and provide a glossary of terms to help clarify any remaining questions about the process.